Hello everyone, my name is Geetanjali Singh and I am currently interning at LEXIS and Company, and the topic for today's video is rule of lis pendens under property law. Now the meaning of lis pendens is a pending legal action wherein lis means the suit and pendens means continuing or pending. This doctrine has been derived from a Latin maxim that is ut pendent nihil innovator, which means that during litigation nothing should be changed. Now this principle embodying the said doctrine is that subject matter of a suit should not be transferred to third party during the pendency of the suit. For example, in the case of transfer of such immovable property, the transferee becomes bound by the result of the suit. Now, this doctrine of lis pendens essentially aims at avoiding endless litigation and protecting either party of the litigation against the act of other or avoiding abuse of legal process. Now, lis pendens is captured under Section 52 of Transfer of Property Act of 1882. This section essentially prohibits alienation of any immovable property when dispute relating to the same is pending in a competent court of law. It is based on the principle that the person purchasing an immovable property from the judgment debtor during the pendency of a suit has no independent right of a property to resist, obstruct, and object the execution of any decree. Now, the purpose of doctrine of lis pendens was, this doctrine was essential as it prevents the transfer of the title to any disputed property without the court's consent, and there can be an endless litigation. It will become impossible to bring a lawsuit to a successful termination if alienation are permitted to prevail and convenience are not imposed. Now, the transfer pendent light is bound by the verdict just as it were the party suit, and the transfer should be subservient to the result of pending lawsuit. Now, the conditions where the applicability of this doctrine is applicable is provided under Section 52, where a suit or proceeding is pending and the above suit is brought to a competent court within the limited jurisdiction, and the right of the title of an immovable property is directly in question, and there cannot be any collusion. Now, this suit should directly affect the rights of the other parties, and the property in question is being transferred by either party. Now, there are some judicial pronouncements in which doctrine of lis pendens has been derived successfully and been clarified accordingly. Now, in the case of Ayya Swami versus Jairam Mudaliar of 1973, the court held that the purpose of this provision is not to deprive the parties of every just or fair argument, but rather to guarantee that the parties submit themselves to jurisdiction and authority of the court, which shall determine all the rights and claims are placed before its satisfaction of the parties concerned, and so that the right amount of justice can be prevailed against it. Now, in the case of Hardev Singh versus Gurnail Singh, it was a civil appeal of the case 1900. In this, the court ruled that Section 52 of Transfer of Property Act would not make void or unlawful any sale of the contested properties, but only push the purchaser beyond the binding limits of the judgment on the disposition of the conflict. Now, the doctrine of lis pendens is strictly based on a theory of necessity rather than on the theory of notice, governed by the principles enshrined in common law, such as justice, equity, good conscience, and it is therefore pivotal in ensuring that justice is provided without injuring the rights of the either parties. Now, there are some points where the applicability of lis pendens cannot be applicable. Now, number one is a sale made by the mortgagee in the exercise of the power as confirmed by the mortgage deed, in case of any friendly suits, or in cases where the proceedings are collusive, and in the case of suits involving pending transfer by a person who is not the party to the suit, and in cases where the property has not been described in the plaint and in the matters of review, and in case where the transferor is the only party affected, and that's all.